to me, through a political act, not a constitutional procedure, declared that 370 is gone. That's why I said. Now, it is not the case, nor is it the intention of the members of the Kashmir government, whom I took the opportunity of consulting before this draft was finalized. It's not their intention that the other provisions of the Constitution are not to apply. That particular point of view is that these provisions would apply only in cases where they can suitably apply and only subject to such modifications or exceptions as the particular conditions of Jammu and Kashmir may require. I wish to say that no more about that particular point at the present moment. Then we come to clause 2. You will remember that several of these clauses provide for concurrence of the government of Jammu and Kashmir state. Now, these relate particularly to matters not mentioned in the instrument of accession. And it is one of our commitments to the people and government of Kashmir that no such additions should be made except with the consent of the Constituent Assembly, which may be called in the state for the purpose of framing its constitution. In other words, what we are committed to is that these additions are matters for determination by the Constituent Assembly of the state. This is commitment. Now you will recall that in some of the clauses of this article, we have provided for concurrence of the government of the state. The government of the state feel that in view of the commitments already entered between the state and the center, they cannot be regarded as final authorities for the giving of this concurrence, though they are prepared to give it in the interim periods. But if they do not give this concurrence, this clause, if they do give this concurrence, the clause provides that that concurrence should be placed before the Constituent Assembly when it meets, and the Constituent Assembly will take whatever decisions it likes to take. What can be clearer than this? The last clause refers to what may happen later on, which is why it's temporary.
So the paragraph which you read is with reference to clause 2, not with reference to clause 3.
Yes, I'm not saying that. I am just reading.
The last clause is clause 3.
I'm not saying, I'm saying I'm reading it holistically so you know why it is called temporary.
2 and 3 are temporary.
2 and 3 are temporary, no doubt about it, because they have to be actually agreed upon by the legislature, by the Constituent Assembly. Now C3. The last clause refers to what may happen later on. We have said Article 211A, which is 238A, will not apply to Jammu and Kashmir, but that cannot be a permanent feature of the Constitution of the state, and hope it will not be. So the provision is made that when the Constituent Assembly of the state has met and taken its decision, both on the constitution for that state and on the range of federal jurisdiction over the state, the President may, on the recommendation of the Constituent Assembly, issue an order that this Article 306A shall either cease to be operative or shall be operative only subject to such exceptions and modifications as may be specified by him. But before he issues any order of that kind, the recommendation of the Constituent Assembly will be a condition precedent. That explains the whole of the article. Well, there can be nothing clearer than this. I mean, we in hindsight, sitting in 2023, can't interpret a provision except on its terms. We're here to interpret the Constitution. We're not here to legitimize a process which is inconsistent with the express terms of the Constitution. Next paragraph. The effect of this article is that the Jammu and Kashmir state, which is now a part of India, will continue to be a part of India, will be a unit of the future Federal Republic of India, and the Union legislature will get jurisdiction to enact laws on matters specified either in the instrument of accession or by later addition with the concurrence of the government of the state, and steps have to be taken for the purpose of convening a Constituent Assembly in due course, which will go into the matters I have already referred to. when it comes to a decision on the different matters, it will make a recommendation to the president who will either abrogate 306A or direct that it shall apply with such modifications and exceptions that the Constituent Assembly may recommend. That, sir, is briefly a description of the effect of this article, and I hope the House will carry it. This explains several things. One, why it was a temporary provision. Two, Constituent Assembly had not been constituted then. It was envisaged in our Constitution that it will be constituted. And the ultimate authority of abrogating 370 will be left to the Constituent Assembly. And a precondition of that would be a recommendation of the Constituent Assembly for the President to pass on. Absent that, it can't be done. That was the understanding of the lawmakers, of the constitution makers of India, of the Constituent Assembly. That is why it was put in. It was not a temporary provision in the sense that it had ultimately 370 had to be abrogated. That's not the meaning of the temporary provision that we're talking about. In any case, Malaj, a heading of an article can determine the content of the article. Content of the article is clear. So, Malaj, the government of the day was staring at the provisions of Article 370. And according to me, through a political act, not a constitutional procedure, declared that 370 is gone. That's why I said it was tossed out of the window through a political act, not through a constitutional act. Such a political act cannot be determined by the Parliament of India. It's not in the remit of the Parliament of India to take a political decision to abrogate 370. And I will demonstrate as we move along, Malaj, how it was done and in what manner it was done. Nobody can deny that the people of Jammu and Kashmir are with the Union. It's an integral part. Nobody can deny that. But there is a special relationship. There is a unique relationship which is engrafted in 370 itself. You can't jettison that except by following a process which is ordained by law.